Hey folks, Christina here, and in this video, I'm going to walk you through Chapter 7 for our business law class. This is from the OpenStax textbook. So Chapter 7 is all about contract law, and what we're going to do as we walk through today is we're going to look at some terminology, and we're going to talk about some different pieces that are important when it comes to contracts. All right. So, some of that terminology, a contract is simply an agreement between two or more parties, and it is enforceable by law. So, when we think about that, there are some pieces that are required for that contract to be enforceable by law. First, there's an offer, then there's acceptance, there's consideration, capacity, and legality. We're going to break each of those apart separately so we can learn about those. An offer is just a proposal made to demonstrate an intent to enter a contract. Offers must be made with intent, they must be definite and certain, and they must be communicated to the offeree. So the offeree, the person that you're going into contract with, needs to understand that there's a contract being negotiated here. After the offer, we just learned that we have acceptance. So that's the agreement to be bound by the terms of the offer. And terms just means what are the pieces we're agreeing to? Like if I'm going to sell you my car and you're going to give me money, the terms of the offer would be how much money, what is the car, when are we changing the money, when do I get the title? Those are all terms of the offer. And acceptance must also demonstrate the willingness to consent to all of the terms of the offer. Agreement can be destroyed by fraud, misrepresentation, mistake, duress, or undue influence. Next, we have consideration. So consideration has to be included in contracts. Consideration is a thing of value promised in exchange for something else of value. In the example I used earlier, the car for money. The mutual exchange binds these two parties together. Next, we have capacity, and we'll talk about this a little bit more later in this lecture. But basically, the law presumes that anyone entering a contract has the legal capacity to do so. There's some exclusions. Minors are generally excluded or excused from contractual responsibility, as are mentally incompetent folks and drugged or drunk individuals. Like I said, we'll talk about this a little bit more shortly. Legality means the contract cannot be for or about illegal behavior. There is no judicial relief to have the contract enforced, and no behavior in opposition to public policy. So this means you can't violate established laws or be in opposition to safety, health, and general welfare of society in your terms of your contract. It has to meet these pieces of legality. Then there's consideration. Most contracts are only enforceable if one party gets consideration from the agreement. Consideration can be money, property, a promise, or some right or privilege as you go through your contract. All right. Next, we're going to talk about, this might be a new term to you. It's a little bit of an odd one. It's called promissory estoppel. So this is an exception to the consideration requirement for contracts. Promissory estoppel is triggered when one party acts on another party's promise. There is harm or injustice to the party who acted on the other party's promise. And we'll see an example about this that was in our book here in just a moment. There is, oh, I already said that. There's harm or injustice to the party who acted on the other party's promise. It may vary state to state, and Oregon is a promissory estoppel state. Okay, here's some basic elements. There has to be a legal relationship that existed between the parties. A promise had to have been made. There was reliance on the promise that caused one party to act before any real consideration was exchanged. A substantial and measurable detriment occurred as a result of the failure to perform the contract, and an unconscionable result or gross injustice resulted from that broken promise. So let's talk about Bob's busted job offer. This is on page 71 of your text. If you're looking at the PDF version, it's page 81. So in this example, Bob was in a bidding war for a new job, and he turned down a job offer with a company called We Are the Best LLC. That's a company where he lived in Miami, Florida. He accepted his dream offer from Megacorp Company in San Francisco, California, so all the way across the US. The offer contained a specific start date, compensation terms, a benefits outline, and more. But it didn't include relocation expenses or provisions. The company was aware that Bob had plans to move across the country for the purpose of taking on this dream role. So Bob in Miami says, okay, cool. I'm going to break my lease. He spent about $13,000 in moving and traveling costs. And the cost of living in San Francisco, as you can imagine, was much higher than where he lived in Florida. So he spent all this money and everything. And then just a couple of days before his promised and planned start date, he got a call from management at Megacorp saying, you know what, we've decided to go a different direction. We don't actually have a job for you anymore. Poor Bob, he's all the way over across the country, spent all this money to get there, doesn't know anybody. And so, according to our text, if Bob brings a promissory estoppel suit, he will likely be entitled to the cost that he incurred while anticipating the start of that promised role. He also might have the opportunity to get some reimbursement of what he paid in his moving expenses, and he might have an opportunity to be reinstated in his previous job, except we know sometimes people hire folks into our places when we leave a job. So we can't exactly predict what's going to happen with Bob's previous place, but he does meet the requirements to bring a promissory estoppel suit against Megacorp Company in California. All right, next we're going to go to section 7.2 in your chapter. So this section is all about capacity and legality. Certain classes or groups of people that are presumed to have no capacity to contract include legal minors, there are some exceptions to that, those who are mentally ill, those who are intoxicated or otherwise impaired. Now, if these people enter a contract, it can be considered voidable or not legally enforceable. If it is voidable, the person who lacked capacity can have a choice to continue or to exit. Now, there's also a way that you can void a contract by being voluntarily intoxicated. Courts generally do not find lack of capacity to contract for people who are voluntarily intoxicated. Individuals should not be allowed to sidestep their contractual obligations by virtue of their self induced states. Courts also seek to avoid the undesirable result of allowing the sober party to take advantage of the other person's condition. So, as you can imagine, if someone entered into a contract and they said, oh, wait, this contract isn't valid because I was drunk when I signed it, that's going to likely have to go through some legal process to find out, were they drunk? Did the other person take advantage of them? So there will be some questions to note. But typically, intoxication means that you do not have a capacity to enter contract. Our book also talks about breach of contract and remedies. So there's an expectation to perform a contract when you sign it. What that means is if you and I go into contract, we both have some responsibilities that when we sign that contract, we're agreeing that we're going to do these responsibilities. In my car for money example, I'm going to sell you my car, you're going to give me some money, and the money's going to be good money, and the car is going to be a car as I explained it. Breach happens when either of those two parties claims there was a failure without legal excuse to perform any, all, parts, and promises of the contract. So that's what a breach means. Now, when you claim a breach of contract, there's some things that get looked at in our legal system. Some of those questions are, did a contract actually exist? What did the terms of the contract require of each of the parties? Were the contractual terms modified at any point? So if we make a contract and then we modify it, that could impact whether or not we have an actual breach. Did the breach actually occur? Was the claimed breach material to the contract? Did the breach actually involve something that was in the contract? Does any legal excuse or defense to enforcement exist? And what damages or harm was caused? Now, there's an example in your text, which I thought was pretty cool about Christmas ornaments. So, material means when something was substantially different from what was expected under the terms of the contract that's delivered. An example of a material breach. I ordered Christmas ornaments for my store, and the company delivered me a box of candles. That's like substantially different. I wanted Christmas ornaments, I got candles. If I'm a Christmas ornament store, my customers are not going to want to buy candles, probably. A minor breach is despite the breaching party's failure to perform some of the contract, the other party still receives a majority of the goods and services specified in the contract. And an example of this would be, let's say I ordered those Christmas ornaments and there was a short delay, like I was supposed to get them at the 1st of November, but maybe I got them on the 8th of November. Now, the important piece is, did our contract say Christina's going to get her Christmas ornaments by the 1st of November? If it did, then we've got an issue. If it didn't have a specific delivery date, then we could have a minor breach of contract. Our book also talks about remedies. So remedies can be different things. There's money damages, so this could be compensation for financial losses. You could have restitution, which means it restores the injured party to the status quo or where they were before the breach of contract. There could be a rescission. This terminates the duties of both parties under the contract. There could be reformation, which allows courts to equitably change the contract substance. So the courts could say, we're going to, make an alteration to this contract. Then there's specific performance. So this compels one party to perform the promises stated in the contract as nearly as practicable. Okay, I've also got a few resources here for you for Oregon. So we've got our Oregon Revised Statutes. There is some information about contracts in Oregon and also some information about Small Business Owners Guide to Contracts. A note, this one is not from our state in Oregon, it's from New Jersey, but it still has some good information there for you. All right, folks, well, that wraps up this lecture, and I will see you soon for our next lecture on sales contracts. Take care.